Welcome back to Good Law, Bad Law. My guest on this episode is Abe Reich. Abe is the Chairman Emeritus at the Philadelphia law firm of Fox Rothschild, and he is a teacher of legal ethics and professionalism at the University of Pennsylvania Law School, my alma mater. And we're talking about Michael Cohen, President Trump's lawyer, and all the varying, very serious legal ethics violations that he is alleged to have caused in his representing of Donald Trump. Everything from recording conversations with the president, making deals for hush money to Stormy Daniels and others. The role of the lawyer is important as a representative of a client and also as an officer of the court. And although some may be surprised to know, there is actually a very important and very serious set of ethical rules that all lawyers are expected to follow. So we have a fascinating conversation with Abe Reich about those rules and how they apply to Michael Cohen. I know you'll be interested in this episode. Stay tuned. My guest on today's episode is Abe Reich, the Chairman Emeritus of the Fox Rothschild firm here in Philadelphia. And we're talking today about Michael Cohen, President Trump's personal lawyer, and the issues of ethics that have been raised through his representation of Donald Trump. So first of all, Abe, thank you very much for being on Good Law, Bad Law.
It's my pleasure. Thank you for having me.
I want you to start, if you would, tell everybody a little bit about your own background and particularly your background in teaching ethics. I know you teach at my alma mater, Penn Law School, but go ahead and give us a little background.
Yeah, I've been practicing law in Philadelphia at the same firm, Fox Rothschild, for over 40 years, 44 years to be precise. I'm a trial lawyer by training, but one of the things that I have done for at least 35 years is ethics and professional responsibility. I've chaired many different committees at the Philadelphia Bar. I do a lot of continuing legal education for lawyers in that area. And for the past 14 years, I've taught ethics and professional responsibility at Penn Law School, your alma mater.
Yeah.
I wish I could have said I had you as a student.
It was too long ago.
It was too long ago. But I have the privilege of being at the same firm that whole time. I tell people I couldn't find another job, but it's been a great firm.
Yeah.
When I joined, we were about 30 lawyers. Today, we're 850
Wow.
and 22 offices across the country.
Fantastic. And you do print in your law business, you do principally commercial litigation, but you also do a lot of representation of lawyers and law firms.
I do.
So,
and that's where the legal ethics and professional responsibility. I defend lawyers and law firms in legal malpractice case and breach of fiduciary duty cases and a host of violations or alleged violations of the rules of professional conduct, which are the standards by which the legal profession is governed.
And, you know, I'm sure, and we'll see as we go through the multitude of ethics issues that the Trump-Cohen relationship has already shown us, that you could practically teach an entire semester of legal ethics just out of some of the issues we're going to cover. But you mentioned the rules of professional conduct, and I think most people might be surprised to learn that there actually is a code of ethics. There are rules that lawyers, not some, but all lawyers, are really expected to follow. So give us a little background on the rules themselves and why we have that as a code of ethics.
The first formal set of rules in the United States were adopted by the American Bar Association in 1908. They were referred to as the canons of ethics. Right. And I always knew when I started practicing that I was dealing with an older lawyer when he referred to the canons. The canons were replaced in the 50s by the Code of Professional Responsibility, which was a different format, but again, a governing body of legal principles that lawyers had to follow if they wanted to keep their license. And then the American Bar Association in the 1980s did a complete revamp, both in terms of format and substance. And today in every state, the rules of professional conduct govern. They vary from state to state in minor ways. California is the last state in the United States to adopt. They're in the process of adopting the rules of professional conduct today. April 1, 1988, Pennsylvania adopted them. And so once the governing body of the American Bar Association adopted a form of rule, they distribute it to all 50 states, and the states will consider them and adopt them, and some in whole, some in part, with some variation. And so since the 1980s, every state has come on board, and California, again, is just doing it now.
Well, and I'm sure some people out there, maybe many people, think that when they think of a lawyer, they might think of Saul, Better Call Saul, and that standard of professional conduct. But these rules are really quite serious, and the consequences for not following these rules can be quite serious to a lawyer. You mentioned lose your license is one extreme sanction that can happen. Is that right?
Violating the rules of professional conduct can lead to a loss of license. Now, that is the most severe remedy, but you can be sanctioned in a variety of different ways. You could fail to communicate with a client regularly, which could lead to a reprimand by the Supreme Court of Pennsylvania. In Pennsylvania, and it's true in, I believe, every state in the country, the highest court of the state governs the conduct of lawyers in Pennsylvania. So for even what might be not particularly serious transgressions, you could have to appear before the bar of the Pennsylvania Supreme Court and be reprimanded by the justices of the Supreme Court for conduct that violates it. You could be suspended for a period of time, up to 5 years. You could be disbarred, which again is the most severe. But the rules of professional conduct should be taken very seriously. In my 4 decades of practice, I am comfortable with saying that the vast majority of lawyers comply with the rules of professional conduct. It's those who transgress that make the news and tend to give the legal profession a black eye from time to time.
Right. And these rules are so serious and so important that even judges and even Supreme Court justices are required to follow these rules. And sometimes we've seen in our history where a Supreme Court justice or two violates the rules, and they can be held accountable.
That is true, but judges have their own code of judicial conduct. It's comparable in some respects, but the code of judicial conduct govern the standard of judges, and they could be removed from the bench for violating a rule of judicial conduct if it's serious enough.
Right. Okay, so let's set the table. We've got a headline-grabbing set of facts here that we're going to use as the basis for talking about some of the ethics issues that have been raised. But set the scene for us with Michael Cohen, President Trump, and this $130,000 payment that really kicks off this whole issue.
Yeah. Earlier this year, there was clearly an attention grabbing where the public learned that Michael Cohen, who had been the president's in-house personal counsel for over a decade, who had been referred to as his, quote, fixer, in the sense of fixing problems, had made a $130,000 payment to a woman who has been referred to as Stormy Daniels, which was her stage name, for allegedly keeping quiet an affair that she had, or a sexual encounter that she had with the president.
Before he was president.
Before he was president, but the payment was made a few weeks before the election. The initial spin on the story was he did it. The president didn't know anything about it. He paid for it himself by arranging a home equity mortgage, borrowed the money to pay the $130,000 because he thought it was in his client's best interest and there was nothing wrong with it.
And specifically in his client's interest that the details of this alleged affair, which I think was back in 2004, 2006, something like that, that this information should not come out during those final weeks before the 2016
Well,
election?
the spin had a little variation and not dissimilar to so much with the story of this particular tale and the president's escapades. One spin was that he wanted to protect the story from his wife. He did not want to hurt his wife.
Wait,
And
Michael Cohen didn't want to hurt Donald Trump's wife?
that's right, by the
okay.
story coming out.
I see. Okay.
That was a spin when people said, oh, he didn't really want to impact the election. Again, that was, criticized as kind of a dubious position. When he said, well, I was trying to protect this story from his wife. I thought it was in his best interest not to create that division, despite the fact that there had been, so much already in the public that reflected the fact that he was anything but a loyal husband.
Right. Okay. And it's also important. We need to know this as part of our fact pattern here, because it'll come up in a couple of the issues. Michael Cohen paid this $130,000 through a company that he set up,
Correct.
apparently specifically for this purpose.
Correct. Essential Consultants,
Right.
Which is what he created. It was a Delaware corporation, and the money was paid through Essential Consultants.
Okay.
And there was an agreement that allegedly was not signed by the president.
A non-disclosure agreement.
A non-disclosure
Yes.
agreement that he had signed that had penalties, and if anyone is interested enough, the agreement is readily obtainable on the internet, and it is a bit unusual. I have seen, I would say, easily dozens, if not 100, non-disclosure agreements in my career, and I have never, ever seen one that defines confidential information to include sexual relations, not to disclose with X, Y, or Z, any third person. I mean, so
Right.
It was clear what the intent of this non-disclosure was. And it also reflected the fact that this probably was not an isolated incident.
Well, and you probably know the name I'm going to share now. We had George Paquetto on the podcast a number of months ago when the non-disclosure agreement we're talking about first became public, and we picked it apart, sentence by sentence, to talk about whether it could ever be enforceable. And there's a lot of questions about that. Probably most importantly, and it bears on what we're going to talk about first, the fact that there's a line for Donald Trump to sign this agreement,
Right.
but he didn't sign.
Right.
It was only signed by Ms. Daniels, whose real name I believe is Clifford's, and by Trump's lawyer, Michael Cohen.
Right.
So the first question has to do with the role of the attorney. Michael Cohen is Donald Trump's attorney here.
Right.
In making this payment and in settling this issue. It wasn't really a case, it wasn't a lawsuit, but settling this issue for $130,000. If the president is to be believed on this, he didn't know anything about this. He didn't know any of the specifics, he didn't know any of the details. Michael Cohen did, and Michael Cohen made this deal. As an ethics expert, as a teacher of ethics, and in your 4 decades of doing this kind of law, what's the problem with that?
There are a handful of areas that are specifically reserved to the client when it becomes a decision to be made in the attorney-client relationship. First and foremost, you can never settle a case without client authorization. While you may say to yourself, this is in the best interest of the client, it's ultimately the client's decision whether to settle or not. In other areas, you can't make the decision whether you should waive a jury trial or not, whether you should plead guilty in a criminal case or not, whether you could appeal a case or not. Those are the kinds of decisions that are relegated to the client to make. Now, the client may say to you, you have authorization to settle a case at X dollars, $100,000.
Mm-hmm.
You may not talk to the client before you settle it.
In other words, up to 100,000.
Up to 100. And if you can settle it for 50, you have authorization, you can do it.
Mm-hmm.
The spin here was he did not know about it. And therefore, under the rules of professional conduct, and there are a multiple series of rules, cannot be done. And, as this story evolved, as those in the audience, and as you may know, eventually President Trump said the spin was Rudy Giuliani had now become his spokesman, and Rudy Giuliani said, people do it all, lawyers do it all the time.
He made it was nothing.
And I will tell you, Aaron, that in 40 plus years of practicing, I've never done that. I don't know a lawyer who has ever done anything like it. And it's preposterous to say lawyers make these kind of payments all the time. Well, that does not happen.
Let me ask you about the ethics dimension to this, because you mentioned a couple other things that a lawyer must not do without a client's express approval. For instance, waive a right to a jury trial or plead guilty to a criminal charge.
Right.
And I can see why those would be things exclusively reserved to the client, because those are constitutional rights. I mean, a person has a constitutional right to a jury trial in a civil case, and if you plead guilty to a criminal charge, you may lose your freedom. So,
right.
but why can't a lawyer settle a claim? This was a claim, not a lawsuit yet. But why can't, as an ethical matter, a lawyer take that on for a client? He's got an ongoing relationship with this client. He's probably settled other matters similar to this and not similar to this. Why, as an ethical matter, must a lawyer never do that?
Because the rules of professional conduct say it. Rule 1.2 of the rules of professional conduct, in which talk about the scope of the representation, and if you look at the comments, you look at the restatement of law governing lawyers, which talk about what a lawyer can and cannot do. While it's not of a constitutional dimension, while it's not life or death like taking a guilty plea or not, it is, in a civil case, one of the most important decisions that could be made. Do I settle the case or not? And as much as the lawyer thinks it's in the best interest of the client, you can't do it.
What if it were to turn out that that this is before President Trump was president, but what if it would turn out that Trump said to Michael Cohen at some point, if anything like this ever should come up, maybe he had experience in it, had come up before, who knows? But if he says, if anything like this comes up, I give you carte blanche, blanket authority, settle it, resolve it. Don't even tell me about it. I don't want to know. I mean, would that be proper?
You have an argument. If it was me and as a lawyer, I wouldn't do it.
You wouldn't agree to that?
Well, I mean, I would hear him, but before I did it, I would email or write or call the client and say, by the way, you would because you don't know, again, ethics and malpractice. To engage in a serious act like settling a case, the client may say, I didn't say that, or B, that's not the same kind of thing that we talked about 2 years ago. 3, my circumstances have changed dramatically. 4, I would have never paid this SOB,
right?
Whereas I told you to pay, only...
I didn't have that in mind, that much money.
Yeah.
So it's really in part that particular rule and that ethical consideration is also to protect the lawyer.
Totally to protect the lawyer and to protect the client. But, in today's environment, for better or worse, I advise, and again, I represent a lot of lawyers, I advise lawyers you have to practice defensively. Communication is critical to a healthy relationship. Written communication is important to a healthy relationship. Client may tell you something, send it to them in writing. Let them reflect on it. You don't want buyer's remorse after you do something. It happens, it's human conduct, it happens.
And you already mentioned that is another area that the rules of professional conduct cover, which is communication between the lawyer and the client. So
Rule 1.4.
not to communicate about something this important with your client
would be improper.
Okay, that would be a separate ethics violation if
Correct.
it's right that Donald Trump didn't know anything about this.
But then he subsequently said, after Rudy's gaffe that people kind of were critical of, he said, "Oh, I knew about it, and yes, I paid for it."
After the fact, right? After the fact, he said he reimbursed him.
He reimbursed him. That's correct.
Right.
This was a bouncing ball that kept bouncing for a long time.
There's another rule in the rules of professional conduct that talks about prohibition on providing financial assistance to a client.
That's correct.
And so tell us about that. And I mean, I think that's implicated in this too. If Michael Cohen paid out of his own pocket for this.
Here is why it may not be.
Okay.
Rule 1.8 of the Rules of Professional Conduct, which is among the conflict of interest rules, specifically says in connection with pending litigation. There was not pending litigation on this matter. In connection with pending litigation, a lawyer can only advance court costs, but a lawyer is not entitled to pay living expenses, for example, or to pay a settlement for a client. You cannot in connection with pending litigation. I'm sure if you were being challenged on Rule 1.8, advancing expenses for a client, one of the defenses would be there was no pending litigation.
Okay. Well, you brought this up, so let me turn to this distinction now. You mentioned the word malpractice, and lawyers, like other professionals, doctors, architects, engineers, accountants, can be responsible may face a malpractice claim. And as you've told us, you've defended many lawyers and law firms who've been sued for malpractice. So how does malpractice differ from the ethics rules that we've been talking about so far, and how does that play into what we've been talking about so far?
There has to be, in a malpractice case, a breach of a duty. You start as a fundamental, and a duty of competence in representing someone is kind of a fundamental duty. And if you make a mistake, you're supposed to file a case within 2 years, and you wait 2 years and 10 days. You've blown the statute of limitations, as it is often said, and that creates a breach of a duty. You then have to say, was there causation of a loss or harm or damages? In a malpractice case, you need a breach of a duty, you need causation or cause, and the client has to suffer a damage or loss. In a ethics violation, you need none of the above. You violate a rule of professional conduct, whether there is damage or not is not relevant to the equation. In a civil case, it is.
So in a malpractice case, then that would really be the client's claim. So in this case, if there were ever to be a malpractice lawsuit on any of these issues, it would be Donald Trump himself as the client who would have to bring that claim.
That is correct.
But the ethics rules are not, those can be enforced regardless of what the client has to say.
In every state in Pennsylvania, there is the disciplinary board of the Pennsylvania Supreme Court. It is the enforcement arm. They are, in effect, prosecutors that prosecute violations of the rules of professional conduct, charge lawyers, they hold hearings, and ultimately recommend sanctions, whether it's a suspension or a disbarment or admonition or some other sanction, which will ultimately have to be approved by the Supreme Court.
Now, if Donald Trump said, and I don't think he's likely to say this now or not anymore because there's a lot of reports that Michael Cohen may be cooperating with the Mueller investigation against Donald Trump. But if supposing Donald Trump said, hey, it's okay, I mean, he's my lawyer and maybe this might have been a violation of this rule or that rule, it's all okay, I'm all right with it. That wouldn't necessarily prevent the disciplinary board. I guess in this case it would be New York where Michael Cohen practices.
Not at all.
The disciplinary board functions on its own.
You know, a client cannot say it's okay to, it didn't bother me that the lawyer did something that violated a rule of professional conduct. For example, there is a famous case in Ray Himmel out of state of Illinois where a client stole money where a lawyer stole money from a client, and um, the client went to a new lawyer, and rather than reporting the lawyer who stole the money, he settled the case, got her money back, and the problem with it, you are obligated under the rules of professional conduct to report conduct like that, trustworthy, fitness as a lawyer, and the lawyer, because the client said it's okay, Mr. Himmel, and Ray Himmel, was given a 1-year suspension, I believe it was.
That's the subsequent lawyer.
No, the subsequent lawyer for not reporting the first lawyer.
That's fascinating. So the rules not only apply to lawyers, but the rules expect lawyers to report violations committed by other lawyers.
Where they involve trustworthiness, honesty, fitness as a lawyer. If you know another lawyer who has committed transgressions that fall in those categories, you are duty bound. It's often referred to as the Rat-Fink rule. You've got to report the lawyer, and your failure to do so in and of itself can be a violation of the rules of professional conduct.
Now, I know, Abe, you've worked in and around these rules for a long time, and you teach this, and this has been a big part of your practice too. And I know this is going to be a fairly obvious question, but I want to get this out. We've talked about how the ethics rules are different and enforced differently, and there's a reason for that. I'm sure there's reasons for that. Why is it so important? It's important enough that lawyers are expected to rat-fink on another lawyer when it involves trustworthiness. Why is it important that there be this body of rules about lawyer conduct and professional conduct and ethics? And why then is it so important? It's not just a matter of curiosity and sensationalism, what we're talking about regarding Michael Cohen, but it's important to the profession, to lawyering, and to the relationships between lawyers and clients. Why is that so important that these rules exist and that they be enforced?
Number one, the singular purpose of lawyers wear several hats, but one of the most important is a representative of clients. And the rules of professional conduct in 60 plus ways direct lawyers in the manner in which they must deal with clients, from the initial retainer agreement to the termination, to conflicts of interest. So the client-lawyer relationship is critical, and the rules give specific directions so there cannot be any question. The lawyer is also a representative of the court system, and the rules give lawyers guidance to make sure they carry out the integrity of a court system. Without a court system that the public does not have confidence in, is Russia or a different country, not the United States. And the lawyer is also a public citizen that has a duty to the public in general. And the rules of professional conduct direct lawyers and give guidance to lawyers to ensure that the public is well served, even if they're not your client, by the legal profession.
So it really is, it's not just about lawyering, it's really about the law and respect and credibility in the law and the legal system.
That is correct.
Well, let's look at another issue that's come up in the Michael Cohen-Donald Trump relationship, exactly where I was going. Abe's pointing to something in his notes, and it's exactly the point I was going to go to next, which is reports that Michael Cohen was recording, and I think he's actually disclosed the contents of some of those recordings already, that Michael Cohen, attorney, recorded conversations with his client, Donald Trump, without Donald Trump knowing about it.
Correct.
What's wrong with that?
What isn't wrong with it? I mean, on
its face, it sounds horrible, but it's an ethics issue.
Take a practical, everyday occurrence. You call your bank or you call your credit card. The first thing they will say to you, this conversation may be recorded for training purposes, or this conversation may be recorded for some other reason, for accuracy,
quality or something,
quality control.
Right.
And that's not of the level of a fiduciary relationship that exists between the lawyer and the client. It is deceitful. Why are you recording without the client's knowledge? Now, in Pennsylvania, it would be unlawful. There is a distinction among the states in the United States between what is referred to as a two-party state where both parties to the conversation have to consent. And if you record my conversation with you in Pennsylvania and I don't consent, that's a violation of the law. New York is a one-party state.
I have your consent to record this conversation.
You do.
So we're okay.
We're okay.
But in New York, it's one party.
So Michael Cohen lawfully could record Donald Trump's conversation, and he did. And CNN blasted it 45 times in an hour, and I've listened to it repeatedly. And what is clear, and there is guidance in New York, guidance opinions that make it clear that it is improper ethically for a lawyer to routinely record without the client's permission conversations with a client. And they view it as deceitful. And that's a long body of ethical standards in New York that clearly any lawyer with any experience would have known.
What about, now I want to ask about this payment, the $130,000 payment, because we've talked about it from an ethics standpoint. And I'm not asking you to be an expert in criminal law or election law, but if it turns out that Michael Cohen made this payment specifically to make sure that she didn't talk about this alleged affair right before the election, I know there's been a lot of reporting that suggests that could also be an election law violation because it could constitute a campaign contribution or thing of substantial value to the campaign itself. That's obviously something lawyers should be very careful about.
No question about it. Now, I don't claim to be an election law expert, but I have heard the pundits on this issue.
Yeah.
And there's more than a convincing claim that this could fall in that category.
Now, one of the other things that's come up is it was front page news and breaking news all over the networks and all this when it was happening. That as part of a criminal investigation in New York, the U.S. Attorney Office in New York raided Michael Cohen's offices and his home and other places and scooped up a lot of files and computers and things like that. Now, FBI raids happen all the time, but I don't think they happen all that frequently with lawyers. And I think most people probably know the basic idea that an attorney and a client have a protection around their communications, around their
no question about it,
conversations, around their emails, around their letters, and so on. So tell us a little bit about that and about the attorney-client privilege and what's involved there.
The attorney-client privilege, which is one of the oldest principles in the common law of the legal profession, was enacted to give clients a sense of comfort that they could come to a lawyer and open their secrets, the most deep secrets, even illegality, and be comforted by the fact that the lawyer would not disclose those confidences. And as long as the privilege was maintained, those confidences would be kept secret. There are exceptions to it, one being the crime fraud exception, which has come up in this context.
Right, we'll get to that.
But so let's stay with this. Yeah. So as you may recall, when they raided it, to raid a lawyer's office, and in this case the president's lawyer's office, they had to jump through a lot of hoops. This was not done frivolously. It was done with a great deal of substantiation that there was a need for it.
So in other words, they had to get a warrant.
That was approved by a judicial officer. Not only that, within the Justice Department, there are criteria before you can subpoena a lawyer. And as you may recall, once it was subpoenaed, there was a process engaged in by the court that set up a team of U.S. attorneys who were not involved in the prosecution, called a screen team, that would screen these documents to determine are any of these attorney-client privilege. And so they would then allocate the documents in a pile for attorney-client communications and ones that were not. Moreover, the district court judge appointed a retired federal court judge to oversee it and to make her own analysis of the material. And the irony of all of this, they jumped through all of these hoops. They determined that certain tapes were privileged. Rudy Giuliani waived it as it relates to the tape because he said the tapes were exculpatory.
Meaning?
They were going to be helpful to the president,
Right.
and therefore he chose to waive them. How you could have made that judgment on the one tape I've listened to is beyond my comprehension. He may be smarter than all of us and has some grand scheme plan that is going to be an aha moment with the entire public. I just don't see it.
So you've met. It's an important consideration, though, that the attorney-client privilege, and it's there are whole sections in the rules of professional conduct that talk about the lawyer's duty of confidentiality.
That's correct.
This is an ethical issue as well.
That's right. Rule 1.6 is confidentiality of information. In fact, under the rules of professional conduct, any information relating to the representation is to be kept confidential with certain exceptions. That rule is actually broader than the attorney-client privilege. But it, too, can be waived by a client.
Well, that's where we were getting to. So the duty is on the lawyer to maintain confidentiality.
And it's the privilege of the client to waive.
Right. So the client can say, it's okay, this communication can go out, or this recording can go out, or whatever that might be. And apparently, at least as to some of these communications through Giuliani, they did waive that privilege. But some of these documents, which may, and this comes up, I've been doing this for 2.5 decades. So I've seen plenty of examples of this in my practice too, where a document is where there's a claim that it's protected, that it's privileged, but in fact, it's a document that isn't protected because it falls into one of the exceptions. And you mentioned the crime fraud exception. I know people probably heard about that when this story was first coming out a couple of months ago, but explain what the crime fraud exception is to this.
A lawyer can give guidance to a client about ways to comply with the law. A lawyer cannot participate with the client in evading the law or committing a crime. And so if I communicate with my client and tell the client how we can wire funds from Europe or wire funds to avoid the recognition of tax liability or to do things that will violate the U.S. law, we are participating in a crime together. And the rules of professional conduct do not protect, nor does the attorney-client privilege protect communications where a lawyer and client commit a crime together.
So if the client comes into the lawyer in conversation or in writing and confesses to a crime, let's say.
That's right.
That would still be protected.
Past crime protected,
right?
Clearly.
But if the attorney in some way participates in it, I mean, the fact of protecting that confession, let's say, that's not considered participating in the crime by covering it up. Not at all.
Okay. It's a past crime. As long as it's not an ongoing crime.
And not a future bad act of some kind. Like, I'm going to go out and kill this person, or I'm going to go out and commit
in fact,
a crime.
there is an exception in the rules of professional conduct where a lawyer can disclose the intention of a client to commit an act that will cause death or substantial bodily harm or even substantial financial harm. The lawyer has the authority under the rules of professional conduct to make that disclosure because, again, one of the hats that the lawyer does is to protect the public. The client may be a bad actor, but you know that your client's about to go out and break someone's knees. you have the right to call the police and tell them.
Okay. All right. We have to talk about Michael Cohen, lobbyist, but I don't even know if that's a fair word to use for him. It's come out since all these reports have been circulating in the last bunch of months that not only did Michael Cohen act as the president's lawyer in these ways we've been talking about so far, but he really also acted in his own interest to receive funds from some pretty major American companies to use his connection or trade on his connection, sell his connection to President Trump for money. So tell us a little bit about that.
Well, factually, as soon as the president's elected, he gets a job with an outstanding major 100 law firm as a lawyer, number one.
Michael Cohen did.
Michael Cohen. Number two, AT&T pays him hundreds of thousands of dollars. I think it was $600,000 as a consultant. Novartis pays him $1.2 million. Now, I have observed Michael Cohen. He may be in his own cab sphere, very knowledgeable about cab law, but I am willing to bet the house that he knows nothing about FDA, FCC, Federal Communication, Federal Drug Law, or the laws to which these people were paying him a lot of money.
Right. Novartis is a big drug company.
Right. And he had no experience in that. And it was obvious they were hiring him to get insight into the president. Now, the rules of professional conduct, specifically Rule 8.4e, make it improper for a client to state or imply that they have the ability to improperly influence a public official. Now, the argument would be made that that's exactly what he was doing when he was taking. Why would they have given him this amount of money with no experience unless they expected him to be able to influence the president's decision in a way that would be favorable to their economic interests?
Now, but that is something that goes on all the time, right? I mean, people swing around the revolving door in Washington every day of the week. They leave government for a lobbying firm or for industry and roll back into government.
Number one,
people know that happens all the time. So why is this a problem?
He's
or
a lawyer.
Potentially a problem.
He wasn't acting as a lobbyist. He was a lawyer. And lobbyists have certain constraints. Lawyers have further restraints. And he was not hired to lobby the Congress on behalf of an industry or a client. It was frankly unclear what he was hired to do. Indeed, when the public outcry about Michael Cohen and all of his shenanigans were revealed, all of these deals were pulled off the table. He was discharged from the law firm that had hired him, or I should say, his relationship was severed.
Right.
Number two, the general counsel of Novartis stepped down. The relationship ended. AT&T relationship ended. All reflecting, one might say, a guilty state of mind. When the public learned, you paid how much to this guy? What is wrong with you? And so they immediately took corrective action to put an end to it. He was a lawyer, not a lobbyist.
Abe, do you think any of these issues that we've talked about are going to end up on your next law school ethics final exam?
There is, part of these started. I taught in the spring semester at Penn, and the incipiency of the Michael Cohen payment was already out there, and it was great stuff. I mean, we were having played out in the public arena some of the most graphic snafus that a lawyer could do, and we were able to dissect them and analyze them against the rules of professional conduct. So if there's nothing else that has happened in this entire year of Michael Cohen and the president and Michael Avenatti and Stormy Daniels and the Miss America and all these other things, they have taught ethics to the public, to lawyers and law students. And I anticipate that I will continue to teach from these very graphic examples of lawyering at a level that I would never instruct lawyers to engage in.
Well, I did have a wrap-up question, but you just mentioned Michael Avenatti, who's Stormy Daniels' lawyer, and that reminds me, I want to ask you about that. One of the things that's characterized his role in this unfolding drama over these last many months actually was mentioned in a podcast I was listening to. The New York Times did a profile, I believe in the New York Times Magazine recently, and they were talking about this on the New York Times podcast just the other day, how Michael Avenatti has probably broken all the records for the number of media interviews he's done. And I mean, there were times when,
Hundreds.
he'd be in the green room waiting to be interviewed on one set, and there would be a camera crew in the green room with him interviewing him for some other program. The issue of a lawyer engaging in that kind of media for a client, does that raise ethics issues? And
they do.
What
indeed.
Does a lawyer have to worry about?
They do indeed. You have to be careful. The Supreme Court made it clear involving a lawyer in Las Vegas by the name of Gentile, who held a press conference and described the conduct of the police and others in defending his client who had been charged criminally in a certain conduct. And it went all the way up to the Supreme Court in an opinion by Justice Kennedy, who is now retired, said that the lawyer has an obligation not only to be an advocate in the courtroom, but as an advocate in the court of public opinion. So lawyers have, at least since Gentile and probably before, when I first started, you would never talk to the press, advocated in the court of public opinion. But you can't do it in a way that misstates facts, that is going to prejudice an adjudicative proceeding. And the volume of public statements by Michael Avenatti in which he was accusatory of Michael Cohen, of the president, led to the filing of a temporary restraining order in California trying to restrain Michael Avenatti from making any further public comments. Michael Cohen's lawyers did that. Because of the belief in the First Amendment, and because the proceeding was still distant, the court denied the TRO. But in New York, when Michael Avenatti chose to file what's known as a pro hoc vice to be admitted in New York for the specific purpose of getting involved in the litigation in New York, the judge was critical of him and said, if you're going to continue on this public relations campaign, you may not want to be in this court. And so, interestingly, Michael Avenatti had the judgment to withdraw his application to be admitted in that court and has continued to give every interview that anyone wants.
Well, and this isn't a brand new issue either with Michael Avenatti. I mean, I'm remembering back to when I was in law school, and at that time the O.J. Simpson trial was in full swing. And I think every morning on the way to court and every afternoon at the end of the court's session for the day, the plaintiff's lawyer team would come out and stand in front of a bank of microphones, and then
actually the defense lawyer.
The defense lawyers did, and even the prosecutor.
Yeah,
I remember to a lesser extent, but they did it too.
As you may recall, the O.J. Simpson defense team included a lawyer whose specialty was in handling the press conferences after every day of court. That was his role.
Was that the Kardashians' father?
He may have been one of them, but it was...
that would explain a lot if so.
Yeah, but no, that was his role. He
Yeah.
never cross-examined witnesses. He didn't, argue in court. He was the front man before the cameras.
Yeah. So that's interesting that Avenatti is going to maybe have to watch his step.
There are rules of professional conduct that talk about publicity.
Yeah.
You got to be very careful not to prejudice an ongoing proceeding. And
well, I don't want to ask you to bet the house, Abe. I wouldn't want you to do that. But you've been in around disciplinary boards, those boards that that investigate and sanction lawyers for violation of these rules, and in your practice and your teaching. There are a lot of ethics questions, at least at this point, about some of what Michael Cohen's been involved in his work for Donald Trump. Are these the kinds of things that could lead a lawyer to lose his license? And is that something you think there's a serious risk of here for him?
I think there is a serious risk that Michael Cohen could lose his license or could be sanctioned at a lesser degree. But that's probably not a big concern for him at this point. He's got bigger concerns, like his liberty.
Right.
But clearly, there has been enough done that warrant a disciplinary board looking at his conduct. I will not be surprised if someone told me today they're already doing that.
Well, and you can lose or you can be acquitted of a criminal charge acting as a lawyer or being a lawyer and still face disciplinary
No question
sanction.
about it.
I'm thinking of President Clinton specifically, right?
No question
he
about
was
it.
acquitted ultimately during the impeachment trial in the Senate, but then was disbarred.
No question about it.
I believe by the Arkansas Bar Association.
That is correct.
So these
different standards.
Right, different standards. Fascinating stuff. Abe Reich, Chairman Emeritus of the Fox Rothschild firm here in Philadelphia and professor or teacher of legal professionalism and ethics at the University of Pennsylvania Law School. Thank you so much for being on the program.
It's my pleasure. Let's continue to watch this bouncing ball because I think it'll be educational to all of us.
We will.
Thank you.
Thanks, Abe.